distant lands we gather, hearts of fire all along. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. From horizons wild we roam, with thunder in our soul. Every battle brings us home to the stories ages told. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Hey, hello and welcome. It is Saturday and I'm live. I'm alive after yesterday's slightly bust Friday show where we checked out the first witness in the Karen Read case, in the retrial of Karen Read. Now, today we will go more into my wheelhouse, which is labor and employment law. We are checking in on Rushin versus Georgia Department of Labor. And Mr. Rushin was terminated from Twin Peaks in Kennesaw, Georgia, which is in the region of Atlanta, Georgia, Fulton County, Georgia. And he has been through the Department of Labor because they denied him unemployment. So now he has appealed all the way up to civil court, to judge, and he's in front of Judge McBurney. So that is what we are going to check out today. Now, fundamentals here. Georgia is an at-will state, which means that an employer can fire you with or without cause, but there are limitations to the reasoning. If they decide to fire with cause, it has to have a valid reason. And here, Twin Peaks at Kennesaw decided to fire him with cause because of a dispute between him and another line cook. And so what is in front of Judge McBurney is, did the Department of Labor do a error in law? So even though you might find that the cause is ridiculous, the reasoning behind it, why couldn't they just have fired him without cause? Because then he would have been then he would have qualified for unemployment. So all of that things, we will hear Mr. Rushin explain what happened. But enough of me going ahead with this. Let's see. I'm going to prepare here. Dun, 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 dun. I'm going to put this one down here, I think. Here we are. And should I go here? There. That's good. That seems good. Okay. So it's Rushin versus DOL Commissioner et al. And if they did error in law. here is Mr. Rushin.
I'm Judge McBurney. It's nice to meet you. You have, as I understand, I'm going to give you a little background of what I understand we're here for, and then you can clear up any mistakes I made, and then I'm going to turn the microphone over to you. Excuse me. You worked at La Cima Restaurant for many years. You were terminated in 2024. You applied for unemployment benefits. You were denied unemployment benefits with the finding that because you had been terminated for cause, you were not eligible. You appealed that. You got in front of a hearing officer. That ruling was affirmed, that you were at fault for discharge. You challenged that to the Board of Review. The Board of Review affirmed the hearing officer, and you have now brought your appeal all the way to Superior Court, which is the right next stop. And I would like to hear anything and everything you want to say. I just need to, and it may be a reminder. If it's not a reminder, you're hearing it for the first time. My review, while I will listen to everything you've got to say, is limited to errors of law. So you're going to tell me what this was all about and what Sam Wade did and didn't do, but I don't get to consider new evidence. And I also don't get to say to the Department of Labor, you know what, you weighed the evidence the wrong way. You ought to have taken Mr. Rushin's word over Wade's word or whatnot. They've already weighed that and balanced it. And my focus is whether there were errors of law, which could be there's no evidence at all. It's an error of law to deny you benefits if there is no evidence at all that you were terminated for cause. So with that, nice to meet you. Tell me what's going on.
Okay, so Your Honor, I've been working with them for about 10 years now.
And you were a line cook?
Line cook, prep, trainer, I've done everything over there.
And where is the restaurant?
The one I was at, well, I went to several ones, but I was at the one in Kennesaw.
Okay. And is it, what kind of restaurant is it?
It's like a sports bar restaurant.
Sports bar.
Yeah.
Why is it called, so is it the company name La Cima, or is that also the name of the restaurant?
Oh, that's the company.
Okay, what was the name of the restaurant?
Twin Peaks.
Twin Peaks. Oh, there's a Twin Peaks in Buckhead.
Yeah, I've been over there too, yeah.
Okay.
Mm-hmm.
All right, so you're a chef of all types at Twin Peaks in Kennesaw.
Mm-hmm.
All right.
And I've been working with them. I've been training their managers. And it just so happened that time that I had death in the family. I was getting ready to go to a funeral out of town.
Oh, I thought you had just come back from the funeral.
Well, when I came back, that's when they fired me. Because
Okay.
I came in late. And I woke up and I'm like, oh my God. So I called him. I said, look, I just got back in. I got in about 5 o'clock. I had to be there about 8.
So the disagreement that you had with the guy working next to you, the guy with the fish, that was before the funeral?
That was, yeah.
Okay, so that incident happened.
That happened before I left.
I got it. Then you leave for the funeral, you come
For
back,
the funeral, come back.
and they give you
Coming
the,
in the morning, the manager that fired me, actually, he tried to get me fired before he was a manager, which no one never told me, but another co-worker. She said, yeah, he said you done this and done that. And I said, I ain't done nothing like that. And they went and looked on the camera and they said they ain't seen nothing. So the GM, Billy, he never said nothing about it. So I just told the guy, I say, look, when you're coming over there, because he was just like flinging fish. I'm trying to train the manager, help them out, training the managers, and he's just flinging fish. So I just told him, I say, hey, look, when you come over there, you don't need to be flinging all the fish everywhere. You know what I'm saying? I want no fish all on him like that. So he kind of went off and said, da. So I just told him, hey, look, we ain't even got to do all that. I'm just letting you know about the fish. And then, so after that, that's when I got off work and I left. I'm already packed to go. So I went on out of town.
to the funeral. You went out of town to the funeral.
Yeah,
Okay.
I left there and I went on out of town. I rode just like that. I changed everything when I get there. That's why I really want fish on me, because I'm getting ready to
Sure.
leave out of town.
Hmm.
So then I come back and they say, well, you threatened the man and this and that, damn, blah, blah, blah. What am I threatening for? I'm like, what was I threatening for? But see, when I went there that morning, I was so tired. He said, well, we're going to terminate you. I said, well, you know what? I'm going back home to go back to bed. So I went back home and went back to bed. Another manager called me. He said, what happened? I said, I don't know. I said, I went in. He said he wanted to terminate me, so I could come on back home. I was tired. I said, I was hoping to get through the day. So I said, I went back home and went back to bed. And that's when all that started.
Okay.
And then see when we had the hearing and everything, Sam, which is well, she.
All right. A few things here. Now, let's say, okay, say that everything he says here is absolutely correct. That they wanted to have him terminated. And then he went home. And then the manager, the general manager, called him and said, yeah, you're fired. Yeah, you should not have gone home. Yes, I understand. Got back from funeral, all of that. Sadly, in a non-unionized workplace, this is what might happen if you take these rush decisions. Now, I understand why. Got back from funeral, all of that, emotions high, emotions low. With a rep, that rep could have taken that discussion for you. But by going home, it sounds like what we would call refusal to work. And that in itself is a termination with cause. So you might have stepped on it, but we don't know everything yet. So let's keep listening.
She was the one that was there anyhow, but she never produced any evidence. I got video of this, I got statements of that, but none of that was never produced. I mean, there was nothing never produced from no one but her saying this happened, that happened, and that happened. And I just couldn't understand it. That's why I kept appealing. I said, now how can she just say that and I say something and it don't mean nothing?
Had you met Sam before? That was someone you knew?
Yeah, she know I worked in there, my leg hurt. I'm gonna tell you, I worked in there for years, dragging my leg around, trying to make sure that everything gets done in it. And she knows that. Everybody know it.
What was wrong with your leg?
I hurt my leg, a thing fell and hit my leg.
Something that
There
worked?
was another manager there, yeah. He said, you can't get, what is that? Because I ain't really been working with them, one or two of them for so long.
Sure. Workers' comp?
Yeah, workers' comp. I said, well, why not? He said, because you didn't holler it when it first happened. So I said, I ain't never heard of nothing like that.
Yeah, that's not true, if that is what actually was spoken. You can get workers' comp for generally. Check with your local representative. Generally, if you don't discover the injury until later, you can still apply for workers' comp. Because as it happens, if it's not immediately obvious, you can still, if you can refer back to that event, you can still apply for it. Now, many, I won't say many, but certain employers will try to have you to not file for it because that might affect the workplace and insurances and stuff like that.
You know what I mean? So that went on, then my leg just started getting worse and worse. So I'd take off, and Sam be there plenty of times, and she know I was in there. All the managers know I'd be in there dragging my leg around, trying to help them to do. They could see I'm in pain. And I just worked with them. I gave them all I had. And then they just like terminated me like that.
Yeah.
So that's why I just kept appealing, because I'm like, I just can't see this. I mean, I never really worked for nobody for that long, but I just couldn't see it in me to just let it go like
Sure.
that.
And 10 years is a long time. You gave them a lot.
But yeah. And
Did you get your leg checked out? Is it better or what's?
yeah, it's better, yeah.
Okay.
And that comes from working long hours with them. See, the doctor, he told me, he said, Chris, he said, when they give you a break, I said, break? We don't get no break. He said, well, every chance you get, at least try to elevate your leg and put it up. You know what I'm saying? So if I get a little break, I'll go out there and sit in the car. If I'm in the car or the truck, and I'll put my leg up, and then I'll go back in. I said, but man, we don't get no break. I said, we ain't never had a break. I ain't never had a break as long as I'm there. And
yeah, in certain states in the United States, the right to a break is not certain. It's not written in law. I'm not entirely sure how that is in Georgia. Over here, where I practice, you cannot work for more than 5.5 hours straight without a break, an actual pause. That is even at European Union level. Who did he work for? He worked at Twin Peaks in Kennesaw, Twin Peaks sports bar of sorts.
I mean, and that's why I'm like, that's why I just kept appealing, because I'm like, I just can't. And then Sam knows me. She know I work hard up in there. I trained multiple managers in there, you know what I mean, to go on to the other stores and manage. And then they just do me like that. That's the only reason why I kept on appealing.
Okay. Well, and you're entitled to appeal. If you feel like the wrong decision has been made, then you got to keep pushing. Tell me how you've been since then. You're in Florida now? Florida is home?
Yeah, Florida's home. I went back to Florida. Yeah.
You were working?
Well, I was looking for a job there and I couldn't find none. So I was doing some little odd jobs to keep everything going and everything.
Mhm.
But I did finally get another job with Longhorn. So I'm cooking with Longhorn. And they plan on paying me more money. So I cook with Longhorn.
Good for you.
Yeah. So,
Okay. And you're saying it's better pay than when you were at Twin
yeah, they
Peaks?
gave me more money than what I had over there. Yeah.
All right. Do you get breaks?
Well, the thing about Longhorn is I don't have to work as many hours.
Okay. So it's nonstop, but it's not so many hours.
No, but now if I go in there and work at night, the other guys, yeah, take a break. Go on outside somewhere. Yeah, get on out of here.
Good.
So you know what I mean? I'll do that. But the thing about them are, you might work like about 5 or 6 hours with them, which I'm satisfied with that.
Sure.
I don't need 8 hours. You know what I'm saying? So I just stay there and do that.
Good for you. Where in Florida are you?
Well, I've been up here since I filed the thing, so I'm working with the one up here right now.
Oh, you're back in Georgia.
Yeah.
Okay, so which Longhorns?
I'm at the one in Austell.
Okay, well, good for you. It's always good to hear when we have these kind of hearings that someone's back on his feet.
Oh, yeah.
Because sometimes people lose their job, especially when we were around COVID, and like, I can't find anything, and I'm trying. But it sounds like you've got a great work ethic and good experience, and so places should snap you up. I'm glad you are, figuratively speaking, back on your feet. I don't know if that makes your leg hurt, but that's good stuff. Okay, so tell me, you've helped me understand the situation kind of writ large. Your argument is then that the legal error that was made is that the hearing officer basically relied on no evidence, that Sam Wade had no evidence.
Didn't prove nothing. All she did, because he asked, she said, did you submit any of this evidence? She said, no, ma'am. So I'm like, well, now you going, and then she just went on and went with her. So I said, well, she told me you're supposed to present some kind of evidence. Like, I mean, you know what I'm saying? So I just couldn't. That's why I kept appealing, because I'm like, I just can't see this. Just don't let it go like that. And if I'd have known about the EECO, I would have filed something with them, but I didn't find out with them until it was too late.
Okay.
Now, it's longer time in Georgia. You get like 300 something days. But here you only get like 185.
Really?
So the lady said, it's too late. I said, what? But the one lady, she tried to put it in because she thought I had worked in Florida. And then I said, well, I was in Georgia at the time. She said, oh, well, it's too late. She said, I could have got it in for you, but it's too late. So, and then the thing about it is, I didn't even know nothing about them until one of the attorney secretaries told me about it.
Also, difference between non-unionized and unionized. You would, at the unionized workplace, you would have found out this on day one. Now, I understand. Not all people like unions. I understand. Perfectly okay with that. But with that, you also then you have to know everything by yourself. As unionized, you have people checking that for you.
Yeah.
Yeah.
Okay. All right. Well, that's all very helpful. Anything more you want to share?
Well, I mean, I did like the restaurant. I did do a good work there and everything, but I hated that happened like that because
It's a terrible way for it to end.
Because of the one manager.
Yeah.
I mean, that was all on him, really. Anybody else, I'm gonna tell you what they would have done. They would have said, come in the office. They'd have brought both of us in the office. We would have talked, or would have, you know, if there was a problem. and we'd have solved that problem then. This one here, being as though he tried to get me fired before he became a manager when he was a cook, that's where that happened like
You
that.
think he had it? It was he had it out for you?
Yeah,
Okay.
yeah. Mhm.
Well, that's unfortunate because they lost someone who had put in a lot of good work.
Mhm.
Well, Mr. Rushin, what's going to happen next is I need to spend some time with the record because I've got the transcript of the hearing and everything. And so I'll need to look to see what did Ms. Wade present, what did she not present? And that way I can assess your claim.
Okay.
I can send it back down and say you need to look at this in a different way.
Mhm.
I can reverse the decision, or I can affirm the decision. So if I affirm it, then you're still working at Longhorn, doing good work. You just aren't going to be able to collect those benefits that you missed out on. If I reverse it, then they do need to give you the benefits for that window of time when you weren't working. And if I send it back down, you have to go argue it again with a hearing officer or whatever level it gets sent down to. Okay? But I'll need a little time with the record. And you should know, I'm going to end the way I started. My ability to fix things is very limited. You might think, no, I'm filing in court. The judge will get this right. I don't get to tinker with the record that's been made. And so if I find that Ms. Wade actually did admit this one thing or this little thing, slight evidence is enough. It may not be anything that impresses you, but I don't get to second guess that judge. No evidence is not enough, but slight evidence is enough. So I'll be looking at the record, and then I'll enter the order that I think I'm required to by law. It might not be the kind of thing that leaves you and me happy in terms of equity and fairness, but it might be what I'm required to do. My goal is to get it legally correct. And then if you disagree with it, you can appeal it, and the Court of Appeals will say McBurney was legally correct. So we're going to stick with that. But I may make a mistake, and you may want to push it further. But I'm relieved to know that in the meantime, you're making good stakes and keeping people happy at Longhorn. Any questions about any of that?
No, I just want to thank you for giving me the opportunity to come here. And I mean, I didn't know what I was appealing to, actually. I just appealed. They said, appeal to the Superior Court. For what? So I just went on and went with it. I came in town that last day, and luckily I found an attorney upstairs to help me get the papers right.
Good.
And I just went on the file.
Well, you did it. You are, I mean, you not only are you apparently good at the stove as a cook, but you're also good at pushing these agendas along. You have been persistent for good reason. And you should feel good about that at least you're being heard. You may feel like it was a little bit of same team umpiring because it's the board that reviews the the hearing officer. I don't have anything to do with the Department of Labor. I'm neutral. I'm hearing from you, and I'm certainly feeling where you're coming from, which is a legitimate frustration. It just may not, in the end, legally be enough to say, "Oh, Department of Labor, you got it wrong." But we'll see. I will give it a careful and honest look, and I will wish you the best. You will get something. Were you doing e-filing? Like when you filed the things you filed, did you put in how did you know about today's hearing?
Well, I got well, my mom had called me and said there was a letter there about the thing, but the district attorney or somebody emailed me something, and I seen it on there May 29th. So
okay, I promise you the district attorney is not going to be doing anything to you because that would mean you're in trouble. It's not.
There was just a paper there saying, court date 20.
Yeah.
I'm like, wait a minute.
Okay, and did that come via email to you? Okay, good. I'm asking only because my final order needs to get to you so you can say, hey, jackpot, or I appreciate the judge thinking about it. I'm disappointed, but he did what he did. I need to make sure that gets to you, and I will electronically file it. It sounds like when things are e-filed, they do get to you through email.
Yeah, well, I did e-file the papers for this, the thing,
Yep.
So it should be in there, I'm pretty sure.
Okay, well, let me see.
I think that's the only way they do it downstairs.
It is. You can't paper file stuff anymore.
Yeah, that's what happened to me. I was here all day going, I'm like, what?
Yeah, welcome to the new world. I'm looking your case up here, and I may be able to figure out that you're in the system. Here you are. Parties, Mr. Rushin. How about that? Yeah, so the address is your old Florida address.
Just the same.
Okay. Oh, you still have something down there?
Yeah.
Okay. You're just up here temporarily?
Until this gets situated. I said I could transfer down there to work in the.
Longhorn will transfer you down there? Good. So there is an email address. We certainly got that. I don't know how to tell whether that is also associated with e-filing. But we certainly have got that. So one way or the other, we'll get you a copy of the order. Okay?
That's fine.
All right. Anything else?
No, that's it.
I appreciate your time.
I appreciate
You working
yours.
tonight?
No, I'm off today. I told him I had to come to court.
Okay.
Don't work on court day.
All right.
All right, but thank you very much, though.
You bet. Take care.
All right. As of now, I have not seen any decision in this. Now, this is the story that Mr. Rushin told. We don't know what else is in this filing because the filing I have not found. But according to him, he had some kind of dispute with another cook and with a current manager who then fired him with cause. It sounds to me like there is a little bit more to the story. But it's hard to say without the filings. But my immediate reaction here, doing this kind of law, is that just by going home, because he was not officially fired, by going home, he made it into a valid termination with cause. So that is my initial reaction. I will try to get back to this once I get a hold of everything, the paperwork, the filings and everything, because as Judge Burney said, and he explained it very, very thoroughly. I really enjoy listening to Judge Burney because it takes his time to explain. And as he said, they only need slight evidence. They don't need to prove it even 50-50. They only need that slight evidence. So that was this case. Now, day isn't done with Judge McBurney. So let's keep on listening.
Oh, good. Ms. Niles says he is connected to the e-filing system. Yes, so you're looking at your leg. Do we need to get the EMT down here? You need a Band-Aid? We could get you like a Thomas the Tank Engine Band-Aid.
All
right. In what order would you like to do things, Ms. Wood?
Can we do the female first?
Yeah.
Yes.
Yes.
Sure. That's why I asked. I'm just here to do what you guys want to do. We took care. So Ms. Garvin.
Judge,
Yes, ma'am.
I'm trying to find out if the rest of your team is on this actual Zoom, because this is Monica's Zoom.
It is. Ms. Rivers is on. I sent her an email asking that she join the civil one. Ms. Simpson is here in person. And I, if you don't mind reaching out to Ms. Jackson and letting her know what that civil Zoom login is for the unemployment hearing.
Okay.
And I think that's everyone.
Okay.
And then there's your iPad. All right, so Mr. Thomas, we're bringing back in a few weeks, I think. So Ms. Dilligard's still with the interns?
Yes.
Where do you sit 70 interns?
You'll see. In the,
Really?
yeah, they're in there.
Okay.
They're finding out their placements right now, so they're really.
Oh, so they'll spread out, but
Correct.
today all 70 of them are in there and they're being told, you're going to major case, you're going to charging unit. Ah, I quit.
Yeah.
McDonald's.
April Fools.
Hello, Ms. Garvin.
Hi. Sam. What's this? This is just, this is what gets you into court. So this is the case. Okay. Okay. Am I keeping this? I can give it to you again. Let me take a staple out.
Right, let's see. What more we have to...
Mr. Jones, are you ready?
I am.
All right. Well, let's go on the record. This is position 3 from our final plea calendar, State versus Rushin Garvin.
Okay.
Ms. Garvin is here in court with Ms. Wood. Mr. Jones is representing the state. Ms. Garvin, Ms. Wood tells me you are interested in entering a plea in your case. Is that right?
Yes, sir. I am.
Ms. Wood, am I remembering correctly that there are some unindicted cases?
Yes, however, I think it makes the most sense to go ahead on this one, and then we will hopefully work through those at a later date. Those are not holding her in custody.
Excellent. So she could get in, assuming she's in drug court, she could get rolling, and then Judge Krause or I could take pleas on those, or they could be diverted into drug court.
Actually, Judge, I got an email while we've been here. They think she's more appropriate for BHTC.
Great. So Judge Richardson.
Yes. So yes, that's the plan.
Okay, great. So Ms. Garvin, all we're taking care of today is there is a shoplifting case from a long time ago, more than 2 years ago. You were indicted for it last year. We had a little trouble finding you, but we caught up with you.
Yeah.
That's the case we're going to take care of today.
Okay.
You have a couple other shopliftings that will resolve later, but they're not going to stop you from getting into...
BHTC. Thank you.
Exactly. Okay. Mr. Jones is going to put you under oath, ask you a bunch of questions. He's right there. He's also on the screen, so you can look at him either way. And I need you to stop us if you have questions at any point.
Yes,
Okay.
sir.
So if
Yes,
someone says something that doesn't make sense, just say, wait, what's he saying?
Okay.
Okay. Mr. Jones?
Good afternoon, Ms. Garvin. Please raise your right hand as best you can. Do you swear or affirm that the testimony you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may lower your hand. Please state your true, correct, and legal name.
Rushin Garvin.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Just under mental health medication, no illegal drugs, illicit drugs, anything, but it's not stopping me from going to court.
All right.
What do you take medication for?
Mental health.
Right, but is it for depression?
Oh, it's for manic bipolar and PTSD. It's
Okay.
mood stabilizers.
Got it. And do you take those in the morning or at night?
I take 2 in the morning and I take 1 at night.
Did you get your morning ones this morning?
Yes, sir.
Okay. And when you take them, do they make you in any way woozy or drowsy or?
No, sir. It just keeps me at a stable mood.
We like that. And so you're understanding what we're doing right now.
Yes, sir. I understand. Everything is clear.
Thank you.
All right. And how old are you and how far have you gone to school?
I'm 35 years old and I went through 9th grade, but I had my general equivalency diploma.
Okay. And are you able to read, write, and understand the
Articulate.
English language?
Yes, I am.
Do you understand that you've been charged with the following offenses? Theft by shoplifting.
Yes, I understand.
Do you understand that you have a right to plead guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, I understand.
Have you had enough time to speak with your lawyer, Ms. Wood, about all of the facts and circumstances known to you regarding the charges, including any potential defenses?
Yes, I've been able to.
Do you need more time to discuss this case with your attorney?
No, I don't.
Are you satisfied with her services?
Yes, I am.
Ms. Wood, do you waive formal reading of this indictment?
We do.
Do you waive any and all defects in the indictment?
So it.
Ms. Garvin, do you understand that you're charged with 1 count of theft by shoplifting, which is the minimum is 1 year, the maximum is 5 years?
Yes, I understand.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of count 1, 5 years of probation, 100 hours of community service, and she must enter and complete BHTC?
Okay. Cool with that. Yes.
Okay. Ms. Garvin, do you understand that the court does not have to accept that recommendation, and that the court can sentence you to the maximum on each charge and can run those sentences consecutive? I'm sorry, this is only one charge, so the court can sentence you to the maximum on that one charge.
I understand.
Okay. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes. Can you repeat that question, please?
Yes, ma'am. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
I understand.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, I understand.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
I understand.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yeah, I understand.
Are you a United States citizen?
Yes, I am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there will be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, I understand.
Okay. And do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime in the future, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yeah, I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? I'm going to go through all of them, and then you say whether or not you understand.
Okay.
Number 1, the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have these charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges at a trial. Do you understand that?
I understand.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, no one.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, this is me. I'm guilty.
Okay. Ms. Garvin, how do you plead to the charge of theft by shoplifting and indictment number 24 SC 0000023?
I plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 30 days from today to file a direct appeal?
Yes.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Your Honor, the defendant's criminal history shows that there's a shoplifting from 2022. That case is going to be 22 SC 171861. There was another felony shoplifting that was reduced to misdemeanor in 2022. That case number is 20 SC 176432. There's also a financial transaction card there from 2021. That case number is 22 SC 181385. Had this case gone to trial, the state would have been able to prove on January 26, 2023, Atlanta police officers responded to 675 Ponce de Leon Ave, which is the Nike outlet in Fulton County at Ponce City Market, in regards to a larceny shoplifting call. Upon arrivals, Officer arrested one female suspect, which is the defendant, and one male suspect. Inside the defendant's backpack were 18 Nike graphic t-shirts of various sizes and designs. Nike store manager provided an itemized receipt as well as camera footage of the incident. And it looks like Mr. Hall, which was the co-defendant, created a diversion inside of the store by faking what looked like a medical emergency in order to lure the attention so that the defendant and another unidentified male that left could take the items. And that gives basis for the state's recommendation, Your Honor.
Do you think Ms. Garvin qualifies for any mandatory minimum sentencing? It sounds like this would be her third shoplifting.
Yes, Your Honor. So from my belief of the statute, so long as the prosecutor and the defense attorney agrees, we can deviate from that mandatory minimum.
Okay, I think that's right. So you are asking that I deviate from the mandatory minimum?
Yes, Your Honor.
Okay. Got it.
I'll tell you about it. Yeah,
Okay.
we'll talk about it later.
Ms. Wood, we
Yes.
don't have Ms. Jackson yet because we're on a funky Zoom session. So I'm ready to hear from you.
Thank you, Judge. So Miss Garvin, when she was originally arrested on this case back in 2023, she served 121 days, and she's been in custody this time around 40 days after getting picked up on the bench warrant. When I first met with her, our goal, and Ms. Dilgard, we both had the mutual goal of getting her into one of the accountability courts, and then we lost contact with her. So I'm happy that she's back, and she is eager to begin the recovery process with BHTC. Judge, I would just ask the state's recommendation.
Okay.
The only other thing I want to flag for the court is the jail booking screen. I think this will get updated when we finally get a release date. So one of the unindicted cases was a transfer from state court. And so it's in that weird limbo. And so sometimes that trips up the processing out, but I'm going to keep my eye on it. And once we get the release date, I'll send the appropriate emails.
Okay. Got it. Ms. Garvin, do you have any questions or anything you want to add?
No, sir.
Okay. Mr. Hall's kind of disappeared on us. When's the last time you saw Mr. Hall?
The day we got locked up.
Oh, that's it. It's been a minute. Okay. You're ready to do BHTC?
I'm ready, sir.
Great. Well, Ms. Garvin, I find there's a factual basis for your plea that's shoplifting, creative scheme there at the Nike store. I also find that your plea is voluntary, meaning no one's forced you to enter this plea.
Yes, sir.
And it's knowing, meaning you've understood the things we talked about. Do you agree with that?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, which means while you are on probation, if you have a small issue on probation, you and probation will work through that. But if you get arrested, something more serious, you get terminated from BHTC, that'll go in front of a judge. It doesn't sound like there's any restitution, Mr. Jones, because they got all their shirts back.
They got the shirts back, Your Honor.
Okay.
I have a question.
Did you have a question?
One question. I was reading on the BHTC where it says I had to pay something like $300. Is that still mandatory? Is that?
So there is a participation fee for people who are in the accountability courts. It's lower for BHTC. I think it's around $300.
Okay.
But it is pay according to your ability to pay.
Okay.
And so if you're having trouble finding a job or you can't find a job, they help you work through that. So you would never be terminated from BHTC for failing to pay, assuming you really could not afford to do it. If you got a little side hustle and you're making some money, they're going to want you to contribute some of that.
Okay.
So you feel invested in the program that is helping make a difference for you. So yes, there's a fee, but it's payable over a bunch of months.
Okay, cool.
Okay. All right. I'm going to sentence you on count one, to 5 years to serve 6 months with the balance on probation. You've already done 100, by my count, it's 164 days, but you're real close to the 6 months, which is 180 days. More importantly, when I get a date from Ms. Wood that BHTC is ready, I'll enter an order saying, release Ms. Garvin now. I just don't want to say time served because you'll get out and we'll lose you again. So you are going to go from, I guess you're at the city jail. You're going to go from ACDC to Hope Hall and start, and they'll help you with housing if you need help with housing, but you're not going to hit the streets and then decide next Wednesday I'm going to show up at Hope Hall. They're going to pick you up from ACDC,
Right then. and
take you
there.
to orientation, and then you're in the program.
Okay.
Okay. I'm not going to require community service, not because I think that's a bad idea, but one, you do community service while you're in BHTC, and two, it's not productive to have a separate obligation. BHTC is going to take a lot of your time and a lot of your focus. It's important, and that needs to be, especially in the first 60 days, that's what you're focused on. So I'm not going to require the extra community service, not because I think what you did was good, but because I want you to focus on BHTC. Okay. Ms. Wood, may someone in my office sign the indictment? I think it's an accusation on your behalf.
Yes.
Mr. Jones?
Yes, Your Honor.
Ms. Garvin, can we sign your name to the accusation for
Yes.
your guilty plea?
Yes, you can.
All right. So the special condition of your probation is that you enter into and complete BHTC.
Okay.
And we'll leave it at that. Anything else, Ms. Wood?
No, Your Honor, thank you.
Mr. Jones?
No, Your Honor.
Ms. Simpson, what do we tell Ms. Garvin about probation and reporting?
48 hours.
Okay. So Ms. Garvin, even though you're going to
So I'm in
be,
BHPC and probation.
you are, but let me tell you the full story on that. When you get out, you've got 2 days, 48 hours just to plug in with probation. You report, say, hey, it's me, Ms. Garvin. Let them know where you're staying because we can help you find housing. So they have an address, but then probation backs off. The deal is, as long as you are in good standing with BHTC, they've got their own investigators. They're going to be checking on you and making sure you're where you're supposed to be. And probation is just in the background. It's only when you finish BHTC that they're there to help, or if you get terminated from BHTC. If you do well and get through the program, then during all those months that you're in BHTC, you don't have to worry about probation. Okay?
Okay, thank you.
All right.
All right. And you said something about 6 more months. So the BHTC has 6 months to come get me.
No, I did say 6 months. You've already done 5 of those months.
Okay.
So BHTC's got a few weeks to come get you.
Okay.
But I'm not going to let the jail release you until BHTC says we are ready to get Ms. Garvin. If you've already been accepted, really all they're going to need is a medical waiver, unless you already did that too.
I did that too. I did the
Great.
labs.
Good. Then they do, I don't know when BHTC does its orientation, if it's the same as drug court, but it could be every Tuesday. So it could be as early as next Tuesday they come get you. Okay?
Yes, sir.
All right. Be ready for it.
I'm ready.
Thank you, Judge.
I hope they're ready for you.
Okay,
This is yours, okay?
thank
All right, I
you.
put my number on there. Call me with any
Damn,
questions.
that's it.
I'm sorry? Lacey Wood?
Yeah, again, this is why I enjoy listening to Judge McBurney. He takes his time to explain it in a way for to the defendant to understand what is actually going on. I mean, listening to other judges, I mean, McBurney is good at it, Boyd is good at it, Simpson is good at it, but there's a plethora of other judges who just say the things and then off they go. So I really, really enjoy McBurney taking his time explaining this is what's going to happen and why is this going to happen, and no community service because it doesn't serve a purpose. If you're going both to this and then on top of that, no, you need to get better. So, yeah.
No, that's not it.
Oh, okay.
I'm Lacey Wood.
Okay, thank you.
You're welcome.
It's, you got me, yep.
Okay.
That was fun. Next up,
Hawkins, Trayvon Hawkins.
what about moment and 2 cases?
Josh. you
Come
don't
on.
need Anymore. I know.
All right.
I know.
He can wait. we'll get Mr. Hawkins out here. So he's got 2 PIs. Is that let me find his.
Yes.
He committed gun by felon. Okay, the warrant I have probably only captures the first of the 2 PIs. Oh, Simpson's not here. Did she go back? Okay, let's wait till she can come out with Hawkins. And Mr. Hawkins. That's all right. We needed also Mr. Hawkins. Mr. Hawkins is coming out in just a second. The warrant that I have for him relates only to an arrest in April of 24, but I see he's got a 25 PI number as well.
Yeah, he's got a 24 PI and.
Right. So is there anything in the works for a petition or a warrant for the 25 arrest? Because we're only going to cover half the landscape. We can always waive and this and that, but I want to make sure if paperwork's rattling around that we capture it. Did you and Mr. Jones talk about what revocation would look like if it's addressing both arrests or just what's in the warrant?
Miss Dilligard and I did.
Okay, see, she's going to say Dilligard. Oh yeah, it's like time served.
So it's not negotiated, Judge.
Okay, but were your discussions encompassing, hey, he's got 2 cases and not just 1?
Yeah.
Okay. Ooh, it's interesting, the 25 PI is for conduct that's even older than this. It's a 25 PI, but it says the arrest date is April of 24. That's weird.
I'm looking at the petition.
Yeah, it's probably a typo in, I'm gonna look at the commitment. Let's see. No, it says that in April of 2024, Officer Pollock responded to MLK, an assault upon a victim with a firearm, striking him with a gun, not shooting, but striking him, and he had to go to the hospital. But that happened in April of 24. Yeah, but then this warrant's not taken out until, the warrant was taken out in April of 24. Maybe it didn't catch up with him until warrant in custody arrest. Maybe he can talk you through how that flowed, but they didn't serve those warrants on him.
Yeah, because this one.
In April, so the very last day of April this year is when he was in custody for something else, and they noticed, hey, you've got these warrants from April of 24. It's even older than the 20.
The 25 PI
Mhm.
is according to the petition, is from April of this year. But the warrant that the 24 PI is from April of last year.
Okay, and it's correct to say that the 25 PI was an arrest this April, but it's for something he allegedly did in April of 24.
So
Yeah, I'm just looking at it. It's,
technically 4, so, because both of these cases are from April, just 24 and
Yeah,
25.
yeah.
Okay.
I just want to make sure that the 24 PI is different conduct, so I'm gonna look that up. I think it is because the dates they're slightly different. They're the same month a year ago. It was a bad month for him.
I think the 24 PI is less serious.
It's just gun. And that commitment order. Yeah, they pulled him over. He was driving a stolen car. They pulled him over. He had a bulge. And
He had a what?
it was a gun.
Oh.
That's just reading what it says.
Oh. Oh, that pause from Judge McBurney was intentional. That pause was intentional. He was.
Over, he had a bulge, and it was a gun.
Oh, that was so intentional.
That's just reading what it says.
Oh. Oh.
He said he bought the gun on the street for the gun was stolen too. He bought the gun on the street for $500. He knew he was not supposed to have a firearm, but outside factors made him retain possession of one. And he added that most firearms sold on the streets are commonly stolen from vehicles by juveniles. I wonder how he actually said that.
What agency is that? I'm just curious.
APD. It's all
Yeah,
part of the conversation he had with Officer Jikanga.
yeah. I don't think the defendant expressed himself in those words. I mean, you hear this in many reports on how people supposedly have said things. I remember back from the YSL trial when, who was not Munktunk, one of the others, and how how they claim he expressed himself in the plea deal, and it was so clean language, and then he's on the stand, oh, that's not clean language, and so everything in a corporate court is an interpretation. It's one of the big reasons why a report in itself is not evidence. That is why you have to have the cop on the stand talking.
I'm supposed to be on the Discovery teleconference right now.
Uh-oh.
What did she file?
Yeah, Hawkins.
Or do you think she didn't know to bring?
No fishing that. So Judge, all please and sit down to work. Our people is gonna be 48 hours. So that.
Okay. I think that makes sense. I think what would be better would be if we had someone from DCS at orientation, because that's when they get out, they get picked up from ACDC or Rice Street on Tuesday for orientation. And if part of orientation was, and here's Miss Simpson from DCS, then it's a one-stop shop. But that requires someone from DCS to be there every Tuesday, and that may be not realistic. So 48 hours makes a ton of sense.
Come right here.
Hey, Mr. Hawkins. Let me do one thing. I have something else going on at the same time, and I'm trying to juggle that. Let's get on the record in your case. This is 18 SC 159254. You are on probation in that case, and I signed a warrant in September of last year that alleged you were driving a stolen car on Cleveland Avenue, you had a stolen gun, and you got arrested for that, which is a violation of probation. We were talking before you came out here that you actually have a second situation that's not in the warrant, but I think we're going to cover today, assuming you and your lawyer agree, hey, we can talk about both these things, where also in April of last year, you supposedly whacked some guy on the head or in the face or something with a gun. You didn't shoot him, but you hit him with the gun. That's the allegation. You were not arrested for that until this year. I don't understand exactly how that works, but a warrant was taken out last year, but it didn't catch up with you until April of this year. So it's not new conduct, it's just a new arrest. So to recap, you got sideways with the law in two different ways in April of last year. Driving a stolen car, had a stolen gun, and then hitting the guy with a gun. Both those things, if they happen, would be violations of probation. And that's what we're here to talk about. Ms. Simpson, how much time remains on Mr. Hawkins' case?
He has 2 years, 11 months, and 11 days.
Okay. Almost 3 years left on your probation from your robbery case.
Oh.
And we've got these two situations. Ms. Wood, is Mr. Hawkins stipulating to the fact that he has been arrested for both situations, stolen gun and hitting someone with a gun?
Yes, Judge.
Okay. Mr. Hawkins, I want to make real clear, you're not admitting that you did either of those things. You may have. Today isn't the day for you to say I did it. Those will both become indictments sometime soon, and you'll need to deal with them. They'll go to whatever judge they go to. They'll be randomly assigned, so it could come here. Chances are it'll be a different judge. We're going to talk about today what the consequences for your probation should be that you got arrested for these two situations, both of which involve you having a gun. And in at least one of them, you supposedly told the police, the one where you had the stolen gun, I know I'm not supposed to have a gun, but life is complicated, and so I got to have one anyway. Ms. Wood, what is your recommendation for Mr. Hawkins?
Thank you, Judge. So Mr. Hawkins is 26 years old. He's a lifelong Atlanta resident. He has a 10th grade education. He has worked previously in construction. He has one baby on the way. We are asking the court to consider revoking 6 months of his probation and then reinstating he's done right at 1 month so far.
Okay.
Yeah, I don't think so.
Do you know his bond status in the two cases? He must be out on bond on one of them.
Bond on the theft case,
Yep.
and then he's in no bond status for the other one.
Okay, got it. Okay, Mr. Jones?
Yes, Your Honor. So the state just wants to put on the record that Mr. Hawkins was previously revoked back in 2019 when he picked up 19 SC 172021, which was a possession of a firearm by a first offender probationer. The judge in that case gave him a second chance, another chance to retain his first offender status. So now we have this new offense, which is a firearm by a convicted felon and causing harm to a member of society, allegedly. Also, what the state wants to bring more attention to is that he has failed to obtain his GED, which was also a condition, which also shows his skills.
And he has a baby on the way. Women, pick better baby daddies. Pick better baby daddies. Yeah, please.
Beyond what it is that we are here. Therefore, the state's recommendation is that you revoke no less than 18 months of his probation.
Okay. I'm looking at the 18 SC case. Okay, so it looks like in 2019, seeing this, there was the order to revoke 2 years, and that was in connection with the 19 SC case. So he pled guilty to the 19 SC case, and I think it's Judge, I can't read the judge's name, maybe Judge Leffridge, revoked 2 years. Is that right, Mr. Hawkins? Is that what happened?
I went to prison.
Yeah, okay. All right. Think I follow all that. Ms. Simpson, anything you want to add to this discussion?
Our recommendation, I had submitted to Mr. Hawkins for remaining balance.
Okay, all right. Ms. Wood, anything else on behalf of Mr. Hawkins?
No,
Okay. Mr. Hawkins, the case we're here to talk about, the robbery case, you already have been revoked once for new charges, which were 17221. You again having a gun. And in that case, that's the 2 years, 5 served, 2 balance probated. Is that closed out? I guess that time would have expired. Now the 19 SC is closed. Okay. All right. I got 2 more cases where you are again using a gun, carrying a gun, after several judges have made it pretty clear that doesn't work for you. You can't do that. You shouldn't do that. But here you are. That's going to end up getting you hurt in some way or someone around you, like the guy who got smacked in the head with a gun. And I get it, what you were telling that officer, that life is complicated and you may feel that this is what you need to do to stay safe or protect your family or your little baby. But that's not an option for you. And if you do it and you get caught, it's just going to get messier and messier, and you're going to get to know your little baby because mom brings him and he looks at you through the plexiglass or however it is they meet with folks who are in the Department of Corrections. I'm not lecturing you. You're going to do what you do. I just need you to understand that every time you're getting in front of a judge, if it's you and guns again, the numbers are just getting bigger. I don't know what else to say beyond that. Do you have any questions about anything we talked about? No? Okay. Mr. Hawkins, I'm going to revoke 2 years of your probation. I will suspend the balance. So when you're done with your revocation, you will not be on probation anymore. You'll get credit for the time that you've been in. I suspect if and when the state gets around to indicting one or both of these, they'll fold it into something like that. And you won't need to come back here to address those. You probably do that via Zoom through GDC. But that will close out this 18 SC case so it's not hanging over your head anymore. All right. Thank you.
thank you, Judge.
So 2 years and baby on the way. So the baby will be 1.5 years before.
So I need to check on the.
Unless the state chooses to charge him for the 2 gun violations. Then he's no longer a first offender. If he's found guilty, everything that happens between 2018 and now will be in the sentencing document. I would say that's a good decade in prison. Yeah. I don't know this guy. I don't know why he does what he does, but I don't think it's worth it.
This discovery conference, and if it's going to be long, I just need to let them know I exist, and then we'll come out, because it sounds like Mr. Moment will be a moment because she's saying no thanks.
Yes.
Okay.
Let's see if there's one more case. Yep, it is.
I don't know about that. Come on. Instead of having mom.
So one more case, then I'm going.
All right, Mr.
One more case, then I'm going to send you over to the Trial Watch Clips channel, who is premiering this week in Judge Simpson's criminal court.
Moment. How are you?
I'm all right, sir.
Okay. Mr. Moment, you have two cases on the final plea calendar. Today is the last day to enter a plea and have the ability to say no thank you if the sentence you get is something you don't like. So I'm gonna make this up. Your lawyer asked for 5 years probation. The state asked for 5 years to serve 2 years. And I say, I'm going to do 5 years to serve 18 months. Well, 18 months in custody is more than probation. And so you could say, I hear you, Judge, but no thanks. I'd rather go to trial. So you can back out of your plea, no questions asked. After today, you could still enter a plea. You may decide before trial time, man, this is going to not go well in front of a jury, so I want to work it out. And you can enter a plea. You just don't get a step back from that plea if in that same situation, your lawyer asks for probation, I give you a year to serve, you're stuck with that sentence. Just like you would be if you go to trial. If a jury finds you guilty, you don't get to back out of anything. Jury said you're guilty. I have to sentence you. So today is the last day to do a plea where you can withdraw it if you don't like the outcome. Ms. Wood tells me that the two sides are far enough apart, you're not interested in even entertaining that, and you'd like to go to trial. I need Mr. Jones to get onto the record what the offer is so I can make sure you understand it. I'm sure you do, but I need to make a record of that so that we don't come back in 2 weeks saying, well, I didn't know that I could do this. So Mr. Jones, what is the global resolution to if Mr. Moment were interested in entering pleas to his two cases?
Yes, Your Honor. So the global resolution was 10 years to serve 2 in custody, 150 hours of community service, a TVIP, I'm sorry, I think this will be a TVIP class, and then the DUI conditions, which is 40 hours of community service. However, that is included in the 150 hours, a $300 fine, alcohol, drugs evaluation, any necessary treatment, a risk reduction, 1 victim impact panel, and of course, 12 months of probation. It is a mandatory 3 days, but he's already served the time for that, so he would get credit.
Plus you're asking for 2 years anyway, so that would cover all that.
And
Okay.
then stay away from the incident location and no further contact. I'm sorry, no further contact with MYRTHLE. That's the first name. Last name is LEGASPI.
What's that got to do with any? I'm just looking at the charges. It's all DUI type stuff. Why is he staying away from someone?
So I do believe that the first count was criminal attempt to commit a felony. I think that has something.
Relates to a victim.
Correct.
Okay, that's fine. And understood. So Mr. Moment, there's a million conditions. I'm going to distill it to the part that leaves the biggest mark. If you were to enter a plea today to your two cases, the state would recommend that I sentence you overall to 2 years in custody, followed by 8 years on probation. And then there's community service and things like that. But 2 years in custody, followed by 8 years on probation. Do you understand that?
Yes, sir. I understand.
Okay. Are you interested in pursuing a plea along those lines? Or would you like your two cases to go to the July trial calendar? Because they're currently on that July trial calendar.
I'd rather go to the July trial calendar.
Okay. You don't happen to know, Mr. Jones, which of the two cases the state would try first?
I do not know, Your Honor.
Okay.
So I can interject here. I think it would be position 12, the 24 SC is older. I'm going to get a waiver in because this is a new case.
Oh, there's a third case?
No. The position 13 is actually just on for arraignment today.
Oh,
Yes.
Okay.
It's older than the 24 SC case.
Okay.
Yes, so I'll get the waiver in and then Jasmine can get me discovery on that one.
Okay.
But we had already started talking about it in terms of global resolution.
Okay. So, Mr. Moment, your situation is a little more nuanced than I thought. Your final plea applies to the older indictment. It's not older incident. Apparently, you have a DUI situation that's even older. The one that I'm focused on is from August of last year. You've been indicted for that. That's the 24 SC. You have a newer indictment that relates to an older incident. That's a brand new indictment. Ms. Wood has waived your arraignment, meaning she's entered a plea of not guilty for you. I'm gonna let that case catch up. But if you were to go to trial in July, the only one that would be fair for Ms. Wood to be ready for would be the 24 SC case. So the August of last year driving incident. The other one will catch up. And in theory, if you want two trials, we could try the 25 SC case, not in July, August, September, sometime like that. If the 24 SC case didn't go well for you, my guess is you'd end up saying, fine, I'll plead to the other one. Let's package it all together. And things may change between now and the July trial calendar. You may get a better offer. You and Ms. Wood may talk about this more and realize, dang, the state's going to ask for 5 years if you're found guilty. And I don't know anything about the strength of the state's case. It could all be on video, and you could have done a blood test and you were 0.2. I don't know. But the stronger the state's case, the more reason there may be for you to say, I don't like 10-2, but that's better than going to trial. We're not there yet. I will see you in July for at least the 24 SC case. But if Ms. Wood is able to line something up that you're willing to plead to, it sounds like we get both cases together. I'm sorry for the confusion about the second case. We'll get a scheduling order and that'll move along. But the 24 SC case is definitely ready for trial, and that's where we'll send it. Any questions?
No, sir.
Okay. Ms. Wood, anything else?
No, Judge, thank you.
Mr. Jones?
Yes, Your Honor, being that this is my first does the court normally advise the defendant what the total maximum penalty is if he was to go to trial on that he could face if convicted?
No, I'm sure he and Ms. Wood have talked about there are a lot of moving parts. I will note that a whole bunch of the charges in the 24 SC case are misdemeanors. And so we'd be stacking 12-month periods. It's not like there's an aggravated assault and an ag battery and we're up into 40, 50, 60 years in custody. But no, I don't typically do that. I just want to make sure Mr. Moment understands what your offer is, because that's sort of the ceiling from the state at this point. Last thing, Mr. Moment, you understand that this offer of 10 served 2 is the state's offer today. It may not be their offer if Ms. Wood 2 weeks from now says, hey, my client and I have been talking about it. We want to work it out. They could come back and say, well, now it's 10 served 3, and you don't get to recreate whatever today's offer is. You understand that?
Yes, I understand.
Okay. All right. Good question, Mr. Jones. I will see you, Mr. Moment, in July at the latest. If something works out before then, we'll get you over here. Okay?
All right.
Thank you, Judge.
You're welcome.
All right, that was the final case of this stream. Now I'm going to send you over to my Trial Watch Clips channel, where we are going through this week in Judge Simpson's court. Everybody, thank you for showing up. Hit the like button, hit the subscribe button. Also other on Trial Watch Clips channel. Have a good one, and I will see you in the chat on that one. See ya. Bye-bye.